Hello, how is everyone today? Thank you all for joining us and taking the time to join us for AMASIAN's Learning Series. My name is Laura Lottie, and I'm the co-founder and the president of AMASIAN. And we have Sadie Minobe here, attorney with Krueger, Hernandez, and Thompson. She's also the co-director of legal and compliance for AMASIAN. And we are excited to hear Sadie's seminar. And if you could leave your questions in the chat, and we'll answer them at the end. All right, Sadie, it's all you.
Thank you for that introduction, Laura. So yes, as Laura mentioned, I am an attorney with Krueger, Hernandez, and Thompson. We're an estate planning law firm based in Middleton, but we serve clients all over the South Central Wisconsin area. Um, just a little bit about me. I have been with the firm for, well, several years now. I live over on the west side of Madison and came here for law school to go to UW and get my JD and met my husband. And so I never thought that I would settle in Wisconsin, but here I am and I love it. And I'm so glad that you're able to join us today because this is my favorite part of being an estate planning attorney. It is so important for me to educate people, make sure people feel empowered to make informed decisions and not make some of these mistakes that we're going to be talking about shortly. Um, so I also want to tell you a little bit about my firm. So something that really helps us do our job well is we're a part of the American Academy of Estate Planning Attorneys. We're the only members in Wisconsin. And so while our firm is what you might call a small firm, we have 2 attorneys and 3 paralegals, we still have the resources of a much larger firm. So then you came here to learn some of the costly mistakes of estate planning. Let's take a look at some of them. So to give a little context, your options when it comes to estate planning are, it really comes down to 4 things. One is you have no plan at all. So that actually is having a plan in place. It's just not one that you choose. If you have nothing in place that you've created yourself, you're following the state's plan. So through the statutes, the court will have to distribute your assets according to your heirs at law. So if you don't necessarily like all of the members in your family, this might not be good news for you if you don't have something in place. The next option is what I think is probably the most well-known option, and they're a very popular estate planning tool. And a lot of people think if they have a will, their family doesn't have to deal with courts, or they're just completely set. Everything is going to run smoothly after they're gone. But unfortunately, a lot of people don't realize that what a will does is it can only be enforced by the court. So when you have a will, your family has to go to court to enforce that will, to get appointed to run your estate. The third option is a living trust, which you may be familiar with, and it's a good alternative for many families, but not all living trusts are created equally. And I'll discuss that in a little more detail. And then the final option is what we like to call at Krueger, Hernandez, and Thompson legacy wealth planning. And that's something that I'll go into in more detail as well. And that's a way that we do our best to address all of the concerns that can be addressed by estate planning and not just some. So the first mistake is failing to make sure that we are passing on our wealth that we've worked really hard to build through our lifetime without government interference. So like I mentioned earlier, if you don't have a plan at all, if what you have is a will, then your estate will probably have to go through probate. Wisconsin has a $50,000 threshold where if your estate is worth more than that or equal to that, your family will have to go to court to get that out of your name. There are 2 types of probate to discuss, and so we'll take a look at both of them. The first being death probate, the second being living probate. Most people think about probate at death. That's the probate court that comes to mind, but a lot of people don't realize that living probate is also something to be planned for as well. So let me tell you a little bit about living probate. So this is what happens if you have no planning in place and you become incapacitated. So living probate is more commonly known as guardianship or conservatorship. And this is the court proceeding to have someone appointed to look after your assets when you are deemed incompetent. And without proper estate planning, someone else chooses who does this. It's maybe going to be someone that you would trust to do the job anyway, but what matters is you don't actually have that choice. You don't have that agency. And the process is time consuming and it can get very expensive. And then the other type of probate, which like I mentioned, that might be the probate aspect that most people are familiar with. And this is the court process to get assets out of the name of someone who's deceased so that they can be transferred to the people who are to inherit. And this is the only way to do that process. This doesn't apply to things that have been placed in a living trust or that have POD or TOD designations. But otherwise, if you have assets in your individual name, then we need to go through the process of applying to the probate court, having a will admitted if you have a will. And this also opens the door for relatives to contest your wishes. Also, another problem that can happen is that this is not a method that necessarily provides the protections to your beneficiaries that you might want. Whether you are passing things along by having no plan, by letting the state decide how your assets are passed, or through having a will, things are going to go to your beneficiaries outright. You don't have protections against creditor issues that your beneficiaries might be going through, or if your beneficiary has a terrible spouse that you'd like to protect their inheritance from. And then finally, also, if you own real estate outside of the state that you pass away in, so most of us, it's in Wisconsin. So if you had a cottage in North Dakota and you didn't have any planning in place to make sure that could pass without probate, you might have to have probate open in Wisconsin and in North Dakota. And then another mistake number two, a lot of us hear horror stories about people who lose everything to the nursing home. They have to impoverish themselves in order to get qualified for Medicaid so that they can pay for long-term care. And this happens all too often because people don't realize that there are ways to protect your assets from long-term care costs. And that might not necessarily be right for everyone. Some people do feel like they want to pay their own way. But the fact is that the government does provide for ways to protect your assets if you are properly educated about those options and you actually take advantage of them. So it is at least a mistake not to be aware of your options and definitely not to be thinking about how you can protect all of that wealth that you've worked so hard to build. And part of the reason why that's such an important thing to know about is nursing home expenses are extremely high. Currently, an average cost of a nursing home room is $135,000 a year. For a lot of people, that is everything that they own. That's all that they've built to keep them going in retirement. Or, even if that's not, it only takes a few years to burn through $500,000. When it comes to long-term care expenses, there's 5 ways to pay. One is, as I mentioned, use your own money, pay your own way. 2 is buy long-term care insurance. 3 is apply for Medicare benefits, 4, become eligible for Medicaid benefits, and then 5, qualify for Veterans Aid and attendance benefits. Now, like I mentioned, using your own money, you can burn through that very quickly with how high long-term care costs are these days. But also when it comes to buying long-term care insurance, it's really, really difficult, if possible at all, to buy a policy these days that really is worth anything. Because the companies that used to provide really good long-term care insurance plans realized they were not making money on it. And in fact, they were losing a lot. When it comes to Medicare benefits, some people think that they can rely on that to pay for long-term care. And that's true to an extent, but it's only for a certain period of time and only after spending no less than 72 hours in a hospital. And then you can become eligible for Medicaid asset benefits by spending down your assets. And then you can also qualify for Veterans Aid and Attendance benefits, which also has its own asset and resource limitations. And so this is a really specific and complex topic, so I won't be able to get into too much detail today. Although I will let you know on my firm's website, or also our firm offers seminars that do specifically speak on this topic. So I encourage you to take advantage of some of those educational opportunities as well. Planning mistake number 3. I mentioned earlier that your beneficiaries might have a spouse that is not a great person, or you just don't trust them not to try to get their hands on your beneficiary's inheritance. So you may have even heard these horror stories where someone inherits or they're set to inherit and they get a divorce and half of that inheritance walks off with their ex-spouse. And also, not only that, but predators and opportunists, they can take advantage of anyone who's inherited a lot of money, especially if matters are going through probate court. All of that is public record. Anyone can look up and see, okay, who's set to inherit $500 million today. And then also, not everyone is mature enough to inherit a huge sum of money all at once. And that is definitely something to keep in mind as well. So with no divorce protection, up to 50% of what you're leaving to someone, you ideally would want that to make sure your loved ones can live a fuller life, not necessarily this other person from this other family that you don't really have a connection with. And say your kid gets into an accident, it really can happen to anyone. Anyone could be at fault for an accident and be subject to a lawsuit. So you have to think about whether your assets are at risk if a beneficiary gets sued. And then also, again, financial immaturity. This is, I think, one of clients' biggest concerns when it comes to thinking about passing on assets to the next generation. We don't want them to get caught up in get rich quick schemes or start living a lifestyle that actually can't be sustained by their inheritance. So there's really just too many risks to outright handing an inheritance to beneficiaries without some protections in place. So mistake number 4, no remarriage protection. This is a huge thing. And I think a lot of people here may know someone, or maybe you've gone through this yourself, where someone passes away, their spouse remarries, doesn't update their estate plan, doesn't do anything to ensure that their assets will pass to their children from the prior marriage. They pass away, that surviving spouse passes away, all the assets go to the new family that they married into. So this is a way that sometimes people can accidentally disinherit their children, essentially. So this is something that you want to think about. If you are married and you have people you specifically would like to have inherit your assets after you and your spouse are gone, how are you going to make sure that happens if you pass away first? And then this is also especially important when thinking about blended families. Mistake number 5, no retirement plan protection. So you're not really thinking about the best options for how you're passing along your IRA or 401k plans. There are also ways of minimizing income tax impacts to your beneficiaries, and you want to keep those in mind as well. Mostly that applies to IRAs that have required distributions. And then also no bankruptcy protections for your beneficiaries as well. Mistake number 6, like I mentioned earlier, not all trusts, not all estate plans are created equally. So a mistake would be something that I see fairly commonly is someone comes in and they've done a DIY trust, or it's a very bare bones trust. And the only idea behind it is to pass things on without probate. Some of the mistakes I see is that they're not properly funded, meaning assets haven't properly been transferred into the name of the trust in the way they should be. They haven't been updated as the client's lives have gone on or as the deceased person's life went on after creating the trust. Often it only addresses death probate. Like I mentioned again earlier, a lot of people think about death probate. They don't think about living probate or guardianship. They won't have nursing home protection and also no protections for their beneficiaries in the event that that beneficiary is going through something where you don't want to give them a whole lot of money at once because it only makes the situation worse. And then finally, they're not taking the time to actually capture their legacy. So that's their non-financial wealth that they would like to pass on, like their memories, their learned experiences, and all of the wisdom that they would like for future generations to know. Mistake number 7 is not making sure that you're thinking about how your beneficiaries will work together or not be able to work together after you're gone. So we don't want to just make sure we're thinking about passing on your money, but also what's that going to do to your family in terms of the fights that it might cause. Even families that get along really, really well, vacation together multiple times a year, they can be torn apart because things can change when someone passes away. So that's a problem that we see with traditional estate planning. It only focuses on money and property. It's not thinking about the people who are to receive it. So this is a time, after someone's death that people should be coming together and not be torn apart. So to summarize an ineffective estate plan, to summarize an effective plan, because I've told you all the problems with an ineffective plan, we have protection from living and death probate. We have protection from nursing home costs, if that's something that's right for the family. We're thinking about protections for children if they get divorced or if they are subject to lawsuits or creditors. Protections for your family if you pass away first and your spouse remarries. Making sure that we're thinking through tax consequences of how we're leaving our assets to beneficiaries, and also preserving your non-financial wealth. So life values, your stories. Some basic estate planning documents I want to review just shortly. So again, we have all the context we need to recognize what an estate plan should be. So I mentioned a will that does equal probate in most cases, if that's what you're relying on, because probate is how a will is enforced. And a will is intended to tell the court, here's who I want to have in charge of my estate. Here are the people who I want to have inherit. A durable power of attorney for property is a method of ensuring that if you become incapacitated, you get to choose who takes over your assets in that case. Your family won't have to go through a guardianship proceeding because you'll have taken care of that. And similarly for your healthcare documents, so things like a durable power of attorney for healthcare or a living will / advance directive, as they're also known, that can make sure that guardianship isn't needed if you can't make your own healthcare decisions. We also want to keep in mind HIPAA authorizations. A lot of people and most of our clients or all of our clients are going to walk away with an authorization that will allow their healthcare agents to actually access the healthcare information they need to make those decisions. And then finally, an authorization for final disposition is a document that's very important because this is how you designate the one and only person who has final say on what happens to your remains after you're gone. Whether you're buried or cremated, what happens to your cremated remains, whether they're split amongst the family, whether they're taken to a very special place. So these are all aspects of a comprehensive estate plan that someone should be thinking about. And then we get to the other option that I mentioned, which is what we find to be one of the best aspects of a comprehensive estate plan. Not every estate plan is right for everyone, but this is right for a lot of people. And the reason why we think it's better, definitely than having no plan, but also more effective than a will in a lot of cases, is it does avoid probate. So it's more efficient and cost effective in a lot of cases. You can build in protections for your beneficiaries, whether it's from divorce or creditor issues, or if you have a disabled beneficiary that you would like to leave assets to, it's an excellent way to do so. And when you combine it with other documents, it can protect your wealth from nursing home expenses or other long-term care costs. And then also it can implement ways to save on estate taxes. So like I mentioned earlier, traditional estate planning, it's only thinking about money and how it's getting passed. It's not thinking about specifically what it's going to do to those people it's being passed to. So it has a narrow view of what's valuable. It's maximizing income, avoiding court costs, reducing taxes, eliminating fees, controlling distributions. And of course, we really should be thinking of all of those, but we shouldn't be taking this narrow view. Instead, what we want to do is a more holistic view. So we believe it's the wrong focus to just look at the money and where it's going. We also want to look at everything that impacts the family. And also, a lot of people feel guilty or they feel sad because they haven't taken the time to leave behind the memories that they would like their family to be able to focus on, memories about their own childhood, memories about their family. These things can be lost to time. So as I mentioned, we like to take a holistic view. At Krueger, Hernandez, and Thompson, we call that legacy wealth planning. We generally in this plan, it would include a family wealth trust. And we're not just thinking about those things I mentioned earlier of minimizing fees, avoiding taxes, avoiding probate. We're also thinking about family values, making sure that say if we have a child that we don't think is necessarily going to use our money in the best way, we're potentially maybe even using their inheritance to encourage them to take a different path in life, or leaving a good impact on your community through leaving charitable donations to them. So we want to make sure that we're thinking about everything that could impact your family and that we're not only thinking about this narrow view. So how does it work? The magic in all of this is how you hold your assets. So if I were to ask each of you how you hold your assets, how are your assets titled? Typically, it would be you own assets in your individual name. And otherwise, if you're married, it might be that you own assets jointly with your spouse. So you have a joint bank account, jointly owned house. Most of the issues I've talked about today are triggered by the simple question of, if something happens to you, how is someone going to take control of your assets and carry out your wishes? And as long as that title is in your individual or joint name, we have to make sure that either the court can appoint someone to take over those things, or, well, you have a document that sets up for that in advance. So to avoid all that court involvement with all that expense and delay and everything, we want to make sure that the title to your assets are not held in your name. And that way, if you become disabled or die, it doesn't make any difference because the asset's it's not titled in your name. And that probably sounds pretty crazy because you might say, okay, well, I don't want anyone else having control over all of my wealth. I want to be able to make decisions over how my assets are handled. And it's right, and that's right. That's a very real concern. It would be a terrible idea to give someone else total control over your assets while you're alive. But what if I told you that there is a way to take the title out of your name, maintain control while you're alive, and also avoid a lot of these issues that I mentioned before? That probably would sound pretty great, which is why most of my clients do choose to move forward with a living trust. And in doing so, you are taking the title out of your name and putting it into the name of the trust. So ideally, after you have properly funded a trust, all of your assets would be in the name of the trust, including your house, your bank accounts. There are some exceptions, but that's something that you can work through with a trusted professional. And so if anything happens to a client after you create a trust and before it's funded, your trust really isn't doing anything for you. Your trust controls the things that are in its name. So our job as attorneys, when we create a trust for clients, is to get to work and make sure that that process is in motion. because otherwise you really just have this empty box that's not doing anything for you. Now, I would say 99.9% of my clients come into my office for their initial consultation and they say, oh my goodness, I've been meaning to do this for 5, 10, 15, 20 years. And that is really the number one reason why people don't plan, is it's always something that you can put off to another day. And I get that. It really is something that we don't like to think about. On an everyday basis, we want to focus on the things that we look forward to, like our next vacation or our retirement. How are we going to live that out? What sort of trips are we going to take? The second reason people tend not to plan is a lack of knowledge. We don't know what we don't know. I mentioned earlier that sometimes people create a document that hasn't been updated between the creation and their death to account for different changes in their lives. And unless you're an experienced estate planning attorney, there's really no way to keep on top of all of these changes. So my job today is to make sure that your knowledge is current in these areas and to let you know about all the benefits of a proper estate plan. And so I'll also want to say knowledge isn't enough. It's not enough to know that there's these options that are available to get things in motion. You actually need an action plan. And so what we always like to offer is a free consultation. Like I mentioned, it's educating my clients. That is my favorite part of this job, making sure people are empowered to make informed decisions. It's so important. So I would like to encourage any one of you to reach out to my office, take advantage of that free consultation. We can sit down and we can talk through what the different options are, what makes sense for you, and to let you know what to expect. At least for our firm, what we offer is a 5-meeting system. First being where we have your plan design all set up and in place, in paper, so that we know who is to receive what are the best protections we want to build in. Most people come in, they don't know at all what they want their plan to look like. That's our job. We talk you through that. Meeting number 2, plan development starts. We start making sure we're actually getting your wishes onto paper. Within this is also a meeting with, usually it's my paralegal, Renee, where you review your asset information. We make sure we have everything we need to get things properly funded. And then finally, we actually execute your documents. And after that, we don't just send you on your documents and say goodbye. We also provide a lifetime of communication and updates and client events to keep in touch. And now I mentioned nursing home protection. That is a whole other level of planning, and it's kind of a complex topic. So if you want to learn more about it, you can reach out to me. I can point you to our educational events, or you can go to our website, which I'll show you the information for that in a bit. But if we want to shield assets from being taken by Medicaid or going to long-term care expenses, that involves the creation of a different kind of trust. That's where you get into irrevocable trusts. You might have heard that term before. And we can explain all of these details either at one of those educational events I mentioned, or more specifically to you during a consultation with us. So I would like for you to stay connected. If you have any questions, you should be able to get my email, but also you can follow us on Facebook, go to our website. That's where you'll see the schedule of different events that we have that will be available for you to learn a little bit more. And you can sign up for a free newsletter that will also help you keep up to date with different changes in the estate planning world. And then also, if you have any family or friends, point them our way. We'll be happy to maybe come in to a place of worship if you have a church you're involved with or a social group. I love coming in and again, helping to educate people about a topic that seems really intimidating, but doesn't need to be. So if there's any other organizations that you think might benefit from this information, let me know. And with
Thank you
that,
so much, Sadie. Oh, sorry.
oh, no, I was just going to say with that, if anyone has any questions, feel free to drop them in the chat. I think there's a couple that Laura might read out.
Yeah, so sorry about that. So they're wondering, is there a minimum amount required to start a trust?
Oh, I get asked that a lot. And uh, something you'll hear a lot of lawyers say as an answer for pretty much any legal question is that it depends. You might have $100,000 and a trust makes sense, or you might have $300,000 and a trust doesn't make sense. There's really no general bright line threshold for creating a trust. It's really something that's specific to you, and that's something that we would talk through in a personal consultation.
Great. And then do I need an estate planner for each state I own a property in? For example, both Wisconsin and Illinois.
Oh, so you don't need a separate estate plan for each of those states, but you do want a plan in place to make sure that all of the property owned, no matter what state it's in, is accounted for. And so if you're wanting to avoid your family having to go through probate in Wisconsin and in Illinois, then that might be something that you want to look to a trust to do for you. But also, again, everything is different for everyone. So if you want to talk more specifically, I'd be happy to do so.
All right. And does anyone else have any other questions for Sadie?
Well, doesn't look like there are any other questions. Although, again, I am still available for anyone who wants to learn a little bit more about estate planning. But yeah, thank you everyone for listening. I'm so glad that you're able to be here today.
Thank you so much, Sadie. We appreciate you.